Hi, and welcome back to this Tuesday edition of Focal Point on AFR Talk. Brian Fisher is my name, your congenial, convivial, and amiable host. The program is Focal Point. The network is the American Family Radio Talk Network, AFR Talk. Now, I've got a column up today. I've tweeted it out. If you're not on my Twitter feed, Brian J. Fisher is my handle. I encourage you to get a Twitter account, and I try to keep you abreast. I can't do it every day. Sometimes I've got other things on my plate, and I'm not able to stay current, but I like to kind of tweet out stories that are going to be of interest to this listening audience, and not only just tweet out the link to the story, but give you some sort of perspective, some sort of editorial content on it, so you'll not just know about the story itself, but you will have some understanding of the significance of that story. Brian J. Fisher. I've been getting a little more active, being engaged in debates on Twitter, responding to people that will reply to my tweets, and some of those running debates, running discussions can be of interest and can be educational for you. So that's Brian J. Fisher. Also, we've got our Focal Point Facebook page. Focal Point is the place to go. Just open up your Facebook page, put in Focal Point. It'll pop right up. Encourage you to go there as well. And don't forget, we've got apps for the iPhone, for the iPad, and for the Android, so you can catch Focal Point on the go, on the run. We upload the segments on video on our YouTube page, and a lot of times we'll tweet out links to segments that we think may be of particular interest to you. Now, I want to talk in this segment about the Supreme Court decision that will be released tomorrow. We now understand that tomorrow is the day that the Supreme Court decision is going to drop. Now, nobody knows which way the Supreme Court is going to go. We've discovered it's impossible to predict which way they're going to go. Who would have thought that John Roberts would have gone completely out of orbit, completely left the solar system of reason, rationality, and constitutional law to issue the ruling that he did on Obamacare? Basically, John Roberts rewrote Obamacare. He rewrote the thing from the bench, actually rewrote it in two different significant places, and then signed off not on the law that was given to him by Congress, but on the law as he himself had rewritten it. I mean, his ruling was inexcusable and unconscionable in any number of ways. And he, of course, is still on the bench. We have no idea what he is going to do. So we have to be prepared for tomorrow for any eventuality. You know, the ultimate outcome, and this would be the right outcome, would be for the Supreme Court to uphold Proposition 8, to say to the state of California, 7 million voters, you have the right to establish public policy. You have the right to establish domestic policy. You have the right to establish marriage policy in your own state. And we have no authority to interfere with that. That's what ought to happen with Prop 8. Prop 8 ought to be upheld. End of story. Simple, flat, no questions about it, period. Should be a one-paragraph ruling from the Supreme Court. That's what would be right. That's what would be constitutional. Now, everybody says it realizes that's probably not going to be what's going to happen. Anything short of that is a defeat for constitutional law and for we the people, for the Democratic Republic, for our Democratic Republic, democratic form of government, a constitutional republic. Now, when it comes to DOMA, the best outcome would be for the Supreme Court, again, one-paragraph ruling. Congress has the right to establish the definition of marriage for federal purposes, and the 10th Amendment prevents any state from imposing its will on marriage on any other state. The 10th Amendment reserves to states the right to establish marriage policy for themselves. Marriage is not in the Constitution. I repeat, marriage is not in the Constitution. So remember, the powers of action that the central government has, and this includes the judiciary, the extent of the powers of action that the central government has, whether it's the legislative branch, whether it's the executive branch, or whether it's the judicial branch, is spelled out in Article 1, Section 8. If central government tries to do something or does something that is not authorized by Article 1, Section 8, it is acting without any moral, ethical, or constitutional or legal authority. It has no right to do it. Now, you look at Article 1, Section 8, and nowhere in there, nowhere, is Congress, is the central government, given the power of action to decide the definition of marriage for the states. It's not in there. They have no authority to do this whatsoever. This thing basically should, what the Supreme Court ought to say, look, this is not our business. The Constitution doesn't give us any business to intrude in the issue of marriage policy. That's for the states to decide. California's decided they want marriage one man, one woman. You look at Rhode Island, they want same-sex marriage. That's up to Rhode Island. It's not up to us to dictate to Rhode Island what their marriage policy is, not up to us to dictate to California what their marriage policy ought to be. And if the people in Rhode Island don't like it, then they can elect different people and they can redefine marriage in Rhode Island to be the union of one man and one woman. If they have a problem with it, they can fix it, and they ought to have the authority and the power to fix it. The solution should not be dictated to them by these black-robed tyrants in Washington, D.C. So anyway, those ought to be the optimum outcomes, upholding Prop 8 in California, the right of the people to define marriage and enact state law for themselves, and they ought to uphold DOMA. DOMA says for federal purposes, marriage is one man, one woman, and that's appropriate for the federal government. If they're going to hire people, if they're going to pay them, if they are going to grant benefits, then they have the right to decide what marriage is, who qualifies for spousal benefits. That's perfectly right and appropriate for the federal government to decide that. And DOMA protects the right of states to establish marriage policy for themselves. They cannot. They are exempt from being dictated to by another state. No state's marriage policy can be determined by what another state does. So you cannot, under the Constitution, have somebody going and getting married in Massachusetts and then going to Texas and saying, you have to recognize my marriage no matter what your state constitution says. That's the whole point of the 10th Amendment, that kind of interdiction, that kind of dictation, that kind of tyranny is prohibited by the Constitution. Now, I want to talk for just a few minutes about what our options are if the Supreme Court issues a disastrous ruling tomorrow. If they impose same-sex marriage, worst case scenario, they impose same-sex marriage on all 50 states. Now, in the comments I'm about to make, I want you to understand I'm just speaking for myself. This is for the purpose of discussion. It's for the purpose of debate. I have ideas that I think need to be a part of the debate. If I didn't believe in these ideas personally, I wouldn't inject them. But I want it to be clear, I'm not speaking for the American Family Association. I am speaking to you in my own capacity as the host of the Focal Point radio program. So this is just me sharing some of my ideas with you. I'm not representing anybody else here but myself. Now, it ought to go without saying, but I want to be abundantly clear about that as we begin. Now, you may be familiar, you may have heard the term nullification. Now, nullification is a legal theory that goes back to 1798. This goes back to Thomas Jefferson and James Madison. They are the authors of the nullification legal theory. Now, I think those guys knew what they were talking about. Thomas Jefferson wrote the Declaration of Independence. James Madison is the father of the Constitution. I think it's safe to say they knew what in the world they were talking about. And they developed in 1798 this theory of nullification. Now, the theory of nullification is very simple. The states created the federal government, not the other way around. The states created the Constitution, not the other way around. The states are the master. The federal government is the servant. Let me repeat. The form of government that was established by the Founding Fathers, the states were the master. The federal government was the servant. Now, you ask anybody in the streets of America today, who's in charge, who's the master, and who's the servant? Is it the federal government or is it the states? Everybody's going to say, well, obviously, it's the federal government. They're the masters. That's the way it's set up. Absolutely, flatly, totally wrong. That's upside down from what the founders intended. The states were the masters, and the federal government was the servant. That meant that if the federal government, as a servant, if it got out of line, if it passed laws, enacted laws that were unconstitutional, the states were under no obligation to give force to those laws because the states were the masters. Federal government was the servant. If the servant starts acting up, then the master has no obligation to give credence and validity to those unconstitutional laws. And this goes, as I say, goes all the way back to 1798. So this theory that I'm advancing, it's not novel with me. It's not my invention. It's not a novel idea. It's been around for 215 years since 1798. And if you got a problem with this theory, then your problem's not with me. Your problem is with Thomas Jefferson and James Madison. I dare you to pick a constitutional fight with them. Go ahead. I dare you. See how far you get with that. Now, it's true that the courts have rejected this theory, but that doesn't surprise me one last little bit, because for the courts to agree with this theory that the states are the master and the federal government is the servant and the judiciary is the servant of the states, not the master, then they would have to accept a lesser role for themselves in American jurisprudence than the exalted one to which they feel entitled. So no surprise, human nature says, yeah, we're going to swat that down as long as we can. Now, the issue here is then not what the courts have done, because I bring this up, everybody says, well, the courts have already decided this. Well, this issue is not what the courts have done, but whether what the courts have done is right. We have to take what the courts have done and stack it up against the Constitution and see if it matches up. Now, this concept of nullification, by the way, is gaining currency once again in our day. I had a story in the Associated Press, it's in the stack, indicating that 80% of the states, 4/5 of the states, have enacted laws that directly reject or ignore federal laws on issues such as marijuana use, gun control, health insurance requirement, and identification standards. So this nullification thing, this is not even an antiquated concept. It's being used today in one state after another where they disagree with what they believe are unconstitutional laws. So Jefferson Madison said, look, federal government is the creation of the states. It's not the other way around. Now, we talked about the powers of action that the federal government has are defined in Article 1, Section 8. Conspicuous by its absence in the Constitution is any mention of marriage. It's not in Article 1, Section 8. It's not anywhere. It's not in the 14th Amendment. People will bring up the 14th Amendment. 14th Amendment, ladies and gentlemen, was not about marriage. The word marriage is not in the 14th Amendment. It was no mention of marriage in the debate over the 14th Amendment. The 14th Amendment, reread it this morning, it's about being sure that newly emancipated blacks were granted citizenship and that they had the right to vote. That's what the 14th Amendment was all about. Blacks are citizens and they have the right to vote. Have the right to vote. Nothing in there whatsoever about marriage. So this is what James Madison wrote. If the Supreme Court overreaches and imposes same-sex marriage on all 50 states, here's what James Madison said back in 1798. When the federal government engages in, quote, a deliberate, palpable, and dangerous exercise of powers not granted by the Constitution, listen to this, the states who are parties thereto have the right and are in duty bound to interpose for arresting the progress of the evil and for maintaining within their respective limits the authorities, rights, and liberties appertaining to them. In other words, if the Supreme Court issues an unconstitutional ruling, the state should just flatly ignore it. Focal Point AFR Talk.